Good afternoon, everyone. Very warm welcome to this rapid response event on the International Court of Justice's advisory opinion on the obligations of states in respect to climate change. This event has been co-organized by the Center for Climate Law and Governance and the Center for International Governance and Dispute Resolution at King's College London. My name is Clara Lopez. I'm a lecturer here at the law school, and I'm also the Deputy Director of the Center for Climate Law and Governance. And I am delighted to chair today's discussion. As many of you will know, just this Wednesday, the International Court of Justice handed down the advisory opinion. So the opinion responds to a request by the UN General Assembly, led by Vanuatu and supported by 132 states, which asked the court to essentially answer to two main questions. First, to clarify the legal duties of states under international law to protect the climate system, and secondly, the consequences of failing to do so. As I'm sure you will all agree with me, this is a landmark moment in the evolution of international climate law. And we are very fortunate to be here today with a panel of experts from King's College London. I am very grateful to all of them for joining us. Who will offer their reflections on a range of legal issues. So I will introduce our speakers very briefly. We have Professor Federico Ortino, who is Professor of International Economic Law and co-director of CIGAT, Professor Megan Baumann, who is Professor of Climate Law and Director of the Center for Climate Law and Governance, Sue Willman Casey, who is Assistant Director and Supervising Solicitor at King's Legal Clinic, and two very special speakers because they were actually acting for states participating in the proceedings. So we have Dr. Leslie Ann Dubich-Paoli, who is reader in environmental law and who acted as counsel for the African Union, and Dr. Nicolo Ridi. He is senior lecturer in public international law and acted as counsel for Ecuador. So the way we have organized this webinar is that we will offer some brief remarks, after which we will open the floor for discussions. Feel free to introduce yourselves in the chat and to ask any questions that you have or that come up as soon as they arise. And we will try to answer as many questions as possible during the Q&A. So without further ado, Leslie Ann, the floor is yours. Thank you so much.
Thank you so much, Clara, and many thanks for organizing this event and really bringing us all together. Many thanks also to colleagues who are joining from far away and remote places during their leave to say a few words at this event. Just two quick disclaimers from myself. I will obviously speak in my personal academic capacity, and the views that I will express today do not represent that of any organization or institutions with which I might be affiliated. And the other disclaimer is that these are initial reactions to offer some thoughts and get the conversation started, but some of the nuances might be lost at this stage, and a detailed legal analysis of the advisory opinion is required. So in my presentation today, I will focus on the advisory opinion and the first question on environmental obligations. It might be worth remembering that the task that was given to the court was really enormous. The question was really asking the court to survey a whole body of law and legal practice that is rich, complex, and spans several decades. And I think in this advisory opinion, the court has offered a rigorous analysis of the main sources of climate law, an analysis that is both focused enough to make the analysis achievable, but nevertheless detailed and in order to reflect the richness of the field. What I'll be doing today is I will not be summarizing or synthesizing all the content of the advisory opinion, but I will try to make a few big picture comments without going into the nitty-gritty of the legal analysis, but I'm happy to answer questions on specific legal findings of the court. What I'll be thinking about is because we know that this is the first time the court is looking at climate change, what is the vision that the court has of this climate problem? And reading behind the lines and looking at what the court has said and not said, what can we say about how the court has conceptualized the relationship between climate change and international law? I will make 5 points, and the first one is, I think, an important one and an obvious one, is that the court has really considered that climate change is a problem defined by scientific consensus. This is the starting point, and it's an important starting point that aligns with the domestic and international climate litigation that we have, is that this advisory opinion relies heavily on the science, and in particular on the reports of the Intergovernmental Panel on Climate Change, the IPCC, that it recognizes as being the best available science. This is significant because the court, since in particular the whaling case, has been engaging with scientific evidence in the context of environmental disputes. The court, in a sense, is focused so much on the science that it spends quite considerable time, for instance, thinking about the precautionary approach and the applicability of these obligations in case of scientific uncertainty, while paradoxically being very clear that there is scientific evidence and scientific consensus on climate change. But it's also using science, I think, in a very strategic way to discuss some points that could have been considered to be controversial if it had come directly from the court. For instance, references to the unequal historical contributions to greenhouse gas emissions from specific industrialized countries is directly mentioned in the words of the IPCC and is not mentioned in the words of the court itself. References to future generations, for instance, are also introduced in the words of the IPCC initially. So the court is very much using this scientific background to justify its findings and also to interpret, obviously, existing treaty and customary obligations. The use of science is particularly significant when the court transforms the aspirational 1.5 target into a legally binding target, and this is quite significant. The objective of limiting global warming to 1.5 degrees Celsius that was considered to be aspirational is transformed by the court on the basis that 1.5 has, in the words of the court, become the scientifically based consensus target under the Paris Agreement. As a result, and this is significant, it allows the court then to conclude that the discretion afforded by the nationally determined contributions is very limited in order to align with this 1.5 target. My second point is that the court sees the climate crisis as part of a broader environmental crisis, and it takes a very holistic approach to environmental change. Put simply, climate law is part of environmental law. Environmental principles are given quite a significant role, building on the non-legally binding Rio Declaration, and the court is giving significant content to customary norms of environmental law that it had already recognized. In particular, and I was quite pleased to, as an environmental lawyer, quite pleased to see that other multilateral environmental agreements, non-climate ones, are given a significant place in this advisory opinion. So there's quite a detailed analysis of a Convention on Biodiversity and the Convention on Desertification that, in my view, were given quite a limited treatment in the proceedings that focus primarily on the free climate treaties, but that the court really offers an analysis of these multilateral environmental agreements and considers that compliance with obligations under these environmental treaties also contributes to the protection of the climate system. So this is important because as we know, one of the main weaknesses of international environmental law is its sectoral, siloed approach to environmental problems. And while the court does offer a fairly descriptive analysis of the duties under other environmental treaties, we can probably expect that this will foster synergies between these three Rio treaties and might have an impact on not only the climate conference of the parties, but also COPs of other environmental treaties. My third point, and I think it's perhaps the most evident one, but perhaps also the most important one, is that the court recognizes the applicability of general international law to the climate problem. So I think it would be fair to say that we have moved with this advisory opinion from international climate law to international law on climate change. We are recognizing that climate law is not a specialized field of international law, and that the whole corpus of international law, including the rules on state responsibility, which Nicola will talk about, is applicable to the climate problem. While there might be some difficulties in mobilizing this corpus of international law, the court was not convinced that this would be an obstacle to their application or applicability. And I think this is quite striking, in particular in the way that the ICJ talks about the applicability of the United Nations Charter, that it considers at the very start to form part of the most directly relevant applicable law. Of course, the Charter does not mention the environment or climate change, but the court very clearly says that due to its obligations regarding cooperation and human rights protection, there's no other way than making climate change relevant under the United Nations Charter. The court, as a result, really positions itself as a guardian of the coherence of international law in the context of climate change. And it's quite interesting to see that it's very much embracing a judicial dialogue, aligning in particular with the advisory opinion of the International Tribunal on the Law of the Sea, not only in relation to the obligations under the UN Convention on the Law of the Sea, but also adopting the same stringent standard to define the due diligence obligation that the International Tribunal on the Law of the Sea referenced. My fourth point is that despite the specificity of the climate problem, the court very strongly anchors this climate problem in interstate relations. So despite the polycentric nature of climate change, with multiple actors contributing to the climate problem and offering solutions to it, the court has managed, I think, in a very clever way to align the mostly bilateral, reciprocal nature of international legal system with the ill-suited nature of climate change. And we see it, for instance, when it's looking at the applicability of a duty to prevent to the climate system. It's not recognizing that the protection of the environment is a value of the international community. Rather, it's just saying this is an extension of a previous jurisprudence on transboundary harm, and climate change and the duty to prevent extends to the climate problem. It even describes climate change as a resource and tries to use its case law on shared resources in order to justify the content of the duty to prevent. So the court does not buy into the arguments that international environmental law would be special and would have unique features that would be different from the core traditional nature of international law. It very cleverly extracted itself from the scholarly noise around climate obligations on the substance versus procedure debate, conduct versus result, bilateral versus multilateral, individual versus collective duties that we've had, just to go to the core and to the essence of the legal obligations. And my last point, which is about what is really missing from this advisory opinion, is about the international law on sustainable development. The court is very much focused on environmental law, but the sustainability aspects are very much missing. This is a bit of a paradox. The court focuses on the Rio Declaration, adopted at the same time as the Convention on Climate Change, but does not seem to be really embracing its logic. The Rio Declaration is a declaration on the environment and development. Development is very much absent from the advisory opinion. Not once is the term poverty mentioned in the advisory opinion. So what is really missing, and that was actually featuring quite prominently in the proceedings, is what does sustainable development really mean? It's only mentioned mostly in one short paragraph. What are the implications of this balancing act between the protection of the climate and economic realities and priorities? It's also quite shy on the differentiation aspects and the principle of common but differentiated responsibilities. Something that is kind of missing is what about the responsibility of emerging economies? The focus is very much on historical emitters, in particular with the emphasis on the Kyoto Protocol. And this argument, we'll still see this argument whereby historical emitters will say that they are transitioning to net zero and are not climate leaders. Emerging economies saying that they need to solve a climate problem and that it's the responsibility of historical emitters. And this has not been solved by the advisory opinion. And finally, I think the advisory opinion also is quite shy in relation to future generations, public participation, considering that treaties on environmental participation are not the most directly relevant applicable treaties. So it's recognizing towards the end that there's a need for social mobilization and that law is not the only solution, but it's not giving the international tools in order to facilitate both this economic and social mobilization. But overall, I think it's offering quite a strong roadmap for perhaps interstate litigation, NDC action, but perhaps less for helping in terms of the trade-offs that need to be made in terms of actual domestic decision-making. And now I'll pass the floor to Dr. Ridi, who's going to talk about the second part of the advisory opinion on state responsibility. Thank you.
Thank you very much, Leslie-Anne. So having acted in this proceedings too, I have to get the same disclaimer out of the way. So my views here are just mine and do not represent or reflect those of any state organization or institution I might have been affiliated with. So, having gotten this out of the way, the advisory opinion is definitely a watershed moment in international law in general, let alone international environmental law or international climate law. 140 pages are many by the court standard, and let me tell you, they are packed. However, in the time available to me, I will focus on the answers to question B, which deals essentially with the legal consequences for states for breaches of climate obligations. So this is the so what kind of question. So in order to tackle that, I would like to start where the court ends, essentially, in the operative clauses in question B. So the court states that a breach of any of the climate obligations it identified throughout the opinion constitutes an internationally wrongful act, which entails the responsibility of that state. And the court also outlines the legal consequences of the wrongful act in terms of cessation, guarantees of non-repetition, the duty to make full reparation, and so on. It does so to a level of abstraction that some of the other judges have found at times wanting, but we'll get to that in a second. So what does this mean in practice and how did we get there? So to understand this, we need to unpack, I would say, 4 issues. There are more issues, of course, but we have time for 4. The first is lex specialis, the second is attribution, the third is causation, and then finally there is a special character of these obligations which have been recognized as erga omnes obligations. So starting with the first, the court essentially had to clear a threshold question. Do the climate change treaties like the Paris Agreement and so on create rules capable of displacing the general rules of international law? This was a general question, but it was also a very specific question in regard to secondary rules. So the rules that apply to the consequences of a breach, and in particular the rules of state responsibility. So in order to answer that, well, some states had argued that these rules do displace the standard rules of state responsibility, and so that the treaties are essentially a negotiated balance, which is there for a reason. So some states such as the US, China, Russia, Japan essentially emphasized that this was an instance of lex specialis, and so the climate regime should have been considered a sui generis type of regime, which displaced, again, these rules of state responsibility, which would have been otherwise applicable. In other words, essentially the idea was we have mechanisms within the Paris Agreement or other treaties for things like loss and damage, and essentially these are intended to be the only avenues for addressing these issues, excluding the recourse by states to other traditional and perhaps, avenues on state responsibility, which may have some more teeth. So the court, to be fair, made very quick work of this objection, and it started with the position advanced by many of the states that promoted the advisory opinion, such as Vanuatu, COSIS, and so on, and the vast majority of developing states, essentially finding no discernible intention in the climate treaties to exclude the general rules. And in fact, it found that the treaties themselves are silent on the consequences of a breach, and the mechanisms such as loss and damage are explicitly cooperative and facilitative and not designed to deal with liability or compensation. Now, this was interesting in itself, but of course it created room for far more discussion on additional points, in particular attribution and causation. Now, let me mention that there was some opposition to the court focusing on these matters. So, for example, Vice President Sebutinde said very clearly that questions relating to attribution or causation are all matters that should have been, as she puts it, in the interest of judicial economy, left to whatever contentious proceedings may one day be brought, rather than addressed in the advisory opinion. Well, that did not happen. So the court did tackle attribution. This was a straightforward state responsibility answer. And essentially, for a state to be responsible, the court found that a wrongful act must be attributed to it. Now, obviously, this creates difficulties because in the context of climate change, this can be complicated. The harm is not only caused by a single act, but again, by the wilderness of single instances, to quote Tennyson, really. So the idea is that there is a cumulative effect of countless public and private actions over decades that can give rise to this kind of damage. Now, there is an important clarification also to be made here. So the court said and clarified this very, very attentively that the internationally wrongful acts that we are talking about here are not the emissions of greenhouse gases per se, but the breach of the obligation to prevent significant harm, essentially. So this breach can be attributed to the state through its own actions or omissions. And this actually was one of the most radical points which the court addressed. So essentially, the court confirmed that the state's failure to regulate the emissions of private actors within its jurisdiction or its actions in actively promoting fossil fuel production through subsidies or licensing and so on can constitute an internationally wrongful act attributable to the state. Now, this morning, in fact, Federica Paddeo and Miles Jackson pointed out on Digital Talk very, very cleverly that the court here did use some very strange language. And in fact, this looks more like a new primary rule than a simple application of attribution. So in practice, it talks about a failure to take action, including through fossil fuel production, etc., etc. But it doesn't quite clarify how this works within the specific framework of the rules of attribution. Now, in regard to causation, obviously, in order to invoke responsibility, an injured state must show that the causal link between the wrongful act of another state and the damage it has suffered exists. And these obviously creates problems. How can a small state facing rising sea levels or anything else prove that its specific injury was caused by the regulatory failures, let's say, of a state thousands of miles away or years ago when many other actors have also contributed to the problem? But this was a central objection, essentially raised by several developed nations, including the US, the UK, many developed countries, really, who pointed at the scientific complexities, really, of attributing this kind of damage in a multi-causal environment. The court essentially acknowledged this, but it distinguished what was hard from what is actually impossible. And essentially it said that the existing legal standards are flexible enough to be applied here. To do so, the court essentially breaks down the problem into two parts. So there is a scientific question of linking anthropogenic emissions in general to climate impacts, and the court accepts these links, as Leslie-Anne has clarified. This is one very, very, very careful deployment of science in this context. And the second part is the legal link. So how do we connect the specific contribution of a single state's wrongful act to the damage? And the court concedes that this has to be done in concreto on a case-by-case basis, but it does state and stresses that essentially when it comes to damage that has concurrent causes, this does not exempt a state from its obligation to make reparation. And in doing so, it adopted the view put forward by a variety of states. Bolivia and the DRC come to mind, among others, which argued that under the rules of state responsibility can be invoked against one responsible state, even when several states have contributed to the same injury. So the court essentially signals that the scientific and legal tools already exist to establish this even in this complex multi-actor context. Now, one point that comes to mind here is that the court's analysis kind of overlooked a distinction, which is the distinction between causation to establish a breach of a prevention duty and the causation that is to be considered in order to quantify compensation. And the standard for the first might be lower than the standard for the second. So this is something that perhaps will be addressed at different points. A final point which I would like to address, which in reality doubles into two different points, and I hope I have the time to discuss them, is the question of the character of the obligations concerned. Now, the court here found that essentially the obligations to protect the climate system are erga omnes, and so they are owed to the international community as a whole. And because they are erga omnes, essentially any state, not just the especially affected or injured states, have a legal interest in ensuring compliance and can invoke this responsibility of breaching state of the breaching state with differences, but we might get there at a different point. The problem, however, is that this creates a bit of a tension in the court's jurisprudence, which was highlighted, I would say, very, very craftily by Judge Tladi. Now, just last year, in the Palestine Advisory Opinion, the court identified breaches of erga omnes obligations. It stated that these breaches trigger strong consequences, essentially for all other states, including the duty not to recognize the illegal situation and the duty to cooperate to bring them to an end. This is, to be more precise, a consequence of a breach of peremptory norms, that is, jus cogens norms. And while we know from Public International Law 101 that all of jus cogens is erga omnes, but the reverse is not true, this creates a bit of an issue. So in the climate opinion, the court identified breaches of erga omnes obligations, but it is silent on the specific consequences of this. And Judge Tladi is very right when he says that this essentially opens a bit of a can of worms, because the court has now conflated the consequences of erga omnes breaches with those of breaches of jus cogens norms. Now, my very final point here, and I promise it is really the final point that I'm going to make, is that there is another, I struggle to call it shortcoming really, but it is another point which the court did not really address. The first was the question of whether or not the court was perhaps a little bit too formalistic in discussing state responsibility in general, because it essentially failed perhaps to recognize that the question posed to it was structured very deliberately to distinguish between the major emitters and the states which were instead especially injured or especially affected. And essentially by treating essentially all states equally, the court ignored this distinction, which could have been significant going forward. And there is a second problem, I would say, that really might amount to a bit of a missed opportunity, which is that the court essentially failed to consider the legal consequences for states for injuries arising from conduct which is not or was not yet, I would say, prohibited by international law, which is something that exists as a concept in the law of state responsibility and is something that could have been addressed. Now, to be fair and perhaps more charitable to the court, this is a separate regime of liability which applies to lawful but hazardous activities such as industrial energy production or transport. Strict liability regimes for damage caused by space objects is one of the examples. There are also other examples where international funds are established to compensate victims of environmental disasters. But essentially, this is a system that creates primary obligations to compensation to victims, which could have been something interesting to address in this context, and the court did not do that. And I would just note very, very much in passing that this also has implications for the relationship between scientific evidence and the use of scientific evidence and the invocation of responsibility from the perspective of causation. So, for example, Judge Nolte observed that even for post-1980s emissions, causation is a major hurdle because science can quantify a state's total contribution, but it cannot determine which specific portions of those emissions resulted from a wrongful act that is a legal failure of due diligence. So in practice, a breach of an obligation of conduct does not automatically translate into a specific quantity of wrongful emissions. And in this regard, it could have been useful to also rely on this category that has been left aside. So this is really my final point, and I thank you very much for your attention. I have, as usual, put too many things on the plate, but thank you very much, and I now give the floor to Sue.
Hi everyone. So in November 2023, the King's Legal Clinic and the Climate Law and Governance Centre held an event called Desperately Seeking the Right to Healthy Climate, which seemed a far-off dream. But now we have it, or do we have it? So what the judgment, what the opinion said about human rights is states have obligations under international human rights law to respect and ensure the effective enjoyment of human rights by taking the necessary measures to protect the climate system and other parts of the environment. I think it's important that other parts of the environment, we've started talking about the climate and nature crisis or the climate and biodiversity crisis. We know the effect of plastics on climate change. So for me, it's very useful that the ICJ mentioned other parts of the environment, not simply climate. I'm going to talk a bit about the extent of this new environmental human right. And then, being a practitioner, I'm going to say something about access to justice and the effective realisation of the right. What does this mean for those people living on an island in Vanuatu who have had to move 4 times away from rising sea levels and now can not move any longer? So since November 23, the momentum has gradually been building. We had the International Tribunal for the Law of the Sea, but they weren't very interested in human rights and didn't make any useful findings. But last year, the European Court of Human Rights in the Swiss case, Klimas Signorinen, found us a right to healthy environment via the route of the right to private and family life. And then in May, we had a very strong finding from the perhaps more radical Inter-American Court of Human Rights on right to healthy environment, and also going somewhere towards ecocide in finding jus cogens in relation to serious and permanent harm to the environment. But all these courts have, of course, focused on an anthropocentric right. So for those of us interested in an ecocentric approach or rights of nature, we don't get that from any of these courts or from the ICJ. The ICJ focused on the right to life, But they then moved on to the right to private and family life. And interestingly, they focused quite a bit on socioeconomic rights as the foundation for the protection of climate through the human rights system. So they talked about the right to health, which has been a contested right, and they talked about the right to water. And then they went on to think about the parasitic rights of so-called vulnerable groups. They talked about states' duties to have particular consideration of women, children, and certain other minorities, such as disabled people and migrants. You'll notice that some minorities are not on that list. They don't seem to have referenced minorities by reference to race or LGBTQ minorities. But for immigration lawyers, the fact that there's a paragraph relating to climate migration, climate migrants is very significant. I think it talks about a non-refoulement obligation where there's a real risk of irreparable harm. So if someone has left a state, I suppose if that top of the Vanuatu island is flooded, then that person may be able to travel to another state, and that state would have a duty not to return them if that threshold is met. So after founding an environmental human right on these existing rights and the enjoyment of existing rights, the court went on to find a human right to healthy environment. And it's to be celebrated that they started off by looking at the history and went back to the African human rights system, the African Charter of Human Rights, which talks about, it's not quite a right to healthy environment, but talks about indirectly a right to a healthy environment. And then they went through other regional systems like the Arab system and, of course, the Inter-American system, which has the San Salvador Protocol, which talks about a right to healthy environment. And so who's missing from that? Well, our own European human rights system doesn't have any right to a healthy environment as yet in the European Convention or protocols to the convention. And this must be a serious call to the Committee of Ministers of the Council of Europe to think again about introducing that right to the protocol. So lastly, I just wanted to say something about the effective realization of these rights. I'm thinking of clients that the legal clinic works with in an Indian river delta called the Sundarbans. They're affected by cyclones. They're affected by changing weather patterns because the monsoon comes early or late. And they're also affected by their islands being flooded. What does this mean for climate justice? Also, thinking about international law and respect for international law. As a human rights lawyer, have to think about the fact that the ICJ has issued more than one judgment in relation to the situation in Palestine in the last 18 months. And we have seen Israel mostly ignoring the measures that were ordered by the court or recommended by the court. We know that Switzerland has been very slow to implement the European Court of Human Rights judgment. And we know that Trump, it's reported this week, is considering a rollback of regulations in the US, which prevent or allow prosecution in relation to pollution and damage to climate. But despite those reservations, I think we have to feel hopeful about this judgment. It's a huge step forward from a human rights perspective. And I'm hopeful that we have managed to all come together today and discuss this, because I think whether the impact of the judgment very much depends on us as academics and practitioners to take a creative approach to the judgment, think about its potential uses, and to disseminate it and discuss it whenever we have an opportunity to do so. It's great that we've seen quite a lot of media coverage of the judgment. Let's hope that continues. And lastly, I listened yesterday to the Prime Minister of Vanuatu, who said, today is different from yesterday. And I think we can feel that the judgment really does mean that today is quite different from November 23. Thank you.
Thank you so much, Sue, and I completely agree with you. So following up on that, I'm going to comment on the effects of the advisory opinion on investment treaty arbitration, which, by the way, have been identified by Judge Cleveland in her separate declaration. And very briefly, the effects can be divided into how the advisory opinion will affect the interpretation of current treaties. This is what I'm going to talk about today, and how it must inform the reform of investment treaties, and Federico will speak to that. So very briefly, I'm going to touch upon 4 points. The first one, which Nicolo already mentioned, is the progressive interpretation of the relationship between the different sources of law upheld by the court. I think that the role of lex specialis developed by the court is something that will certainly have an impact on investment treaty arbitration and the way states construe their arguments before investment treaty tribunals. The second point that I wanted to make is that I think the court did an excellent job in identifying very carefully the obligations of states and detailing what are the components of these obligations. And this would be essential for the application of Article 31(3)(c) of the Vienna Convention on the Law of Treaties in investment treaty arbitration. So a common argument by states in investment treaty arbitration is that the investment treaty must be interpreted in light of the state's human rights and environmental obligations. And very, very commonly, we see corporations saying, well, you cannot interpret the investment treaty in light of those human rights or environmental obligations because those treaties do not constitute the norms applicable in the relationship between the parties for the purpose of Article 31(3)(c). And we can see an example of this, for example, in South American Silver versus Bolivia, where the corporation and the arbitral tribunal decided that the treaty could not be interpreted, for example, in light of the ILO Convention 169 on the protection of indigenous peoples. So the fact that the court has identified obligations under customary international law, which are applicable to all states, and in treaties, in human rights treaties with wide ratification, means that in practice, arbitral tribunals will need to engage in systemic integration. Related to this, my third point is that the court has identified on the customary international law a duty to prevent significant harm. And it has detailed in quite a specific way what does this duty amount to. And it amounts to the duty of states to adopt relevant rules and measures and to, amongst others, undertake environmental impact assessment. Now, this reinforces the arguments of states in investment treaty arbitration that there's not only a right to regulate, there's a duty to regulate, and investment obligations need to be interpreted in light of that duty. In particular, I find the mention to environmental impact assessment very relevant because it is under environmental impact assessment that states regulate the obligations of corporations. And this needs to be considered by investment tribunals. And my last point is on the oil and gas industries. You all know that there's this big controversy between the existence of investment treaties and the obligations of states to not invest in oil and gas deposits. So the court has hinted all along the advisory opinion to the role of states in controlling corporate behavior. So it has already been mentioned, but paragraph 276 establishes that states need to control private actors subject to the respective jurisdiction. And in the part where the court develops state responsibility, the court emphasizes that the lack of or the failure to take appropriate action may amount to an unlawful act. And taking action includes refusing granting of new licenses, controlling fossil fuel production and consumption. So this part of the decision would be very important for the interpretation of investment treaties, and in particular for the interpretation of the fair and equitable treatment and legitimate expectations. So I don't think that any oil and gas corporation can claim that they have legitimate expectations that they will be granted, for example, an exploitation concession. It will also impact the way we interpret exceptions. Arbitral tribunals interpret exceptions because exceptions have not been they haven't had quite a lot of efficiency in investment arbitration. But the decision of the advisory opinion reinforces the role of exceptions in investment treaties. So this leads to Federico, who will speak about structural reform. Thank you so much.
Thank you, Clara. And yes, I mean, I mean, of course, investment treaty system, it is not per se mentioned. There's a really fleeting reference in the advisory opinion. There is, as Clara mentioned, a reference, a couple of paragraphs in Cleveland's declaration. But it's interesting, nonetheless, to examine what could be the effect of the opinion to the specific area of, and quite controversial area of international law. Now, and the question I want to pose is sort of the impact that this duty to prevent significant harm to the climate system will have on investment treaty reform, sort of, going forward, in addition to the impact that Clara has already examined with regard to the interpretation of existing treaties. Now, in other words, does the duty to act with due diligence to prevent such significant harm, as well as the duty to use all means at their disposal to prevent activities carried out within the jurisdiction or control from causing significant harm to the climate system, require states, and that's the question, to modify their international investment treaties, existing and future? Sort of influence future treaties and modify existing ones. Now, it should be emphasized, as has already by my colleagues, that the court has insisted that the standard of due diligence is a stringent one, and also that it is a more demanding standard when it comes to developed country. Now, the difficulty here is that, of course, investment treaties per se do not directly cause climate change, right, or produce GHG gases. However, I think one can argue without really big problem that investment treaties may do so indirectly. And this has been sort of mentioned by Intergovernmental Panel on Climate Change, as has been referred to it, which has been relied by the court quite extensively in its opinion. And the IPCC has acknowledged that international investment agreements may lead to regulatory chill, which may lead to countries refraining from or delaying the adoption of mitigation policies, such as phasing out fossil fuels. Now, based thus on the potential indirect impact of international investment treaties, it can be argued that as part of a broader national policy aimed at using all means to prevent activities causing significant harm to the climate system, states should also attempt to adjust and modify their existing and future investment treaties. Now, that's the first part. The second part, how do you do that? Now, clearly, that's something one could consider, but I'll just offer a couple of ideas. And investment disciplines you find in existing and recent treaties take different forms. Now, the traditional ones is protection, investment protection. Now, I would suggest that states should ensure that investment protection guarantees do not entail cost-benefit balancing or so-called proportionality in the strict sense, as that will allow adjudicators to balance the costs on foreign investments, say fossil fuel investments, with the benefit on public policy, which in our case is climate change mitigation policies, for example. Now, there's plenty of proportionality going on in existing ISDS practice with regard to all investment treaties, but even in recent investment treaties, there is an argument that they do not expressly exclude such cost-benefit balancing. For example, with regard to even the narrow formulated FET clauses or definition of expropriation. You can also think about limiting the scope of investment protection or the right to dispute settlement to investors complying with internationally recognized principles of responsible business conduct, including environmental protection. That's sort of another way in which one could give a form to this duty of due diligence. There are more liberalization disciplines. This is clearly something else that states could do, excluding, for example, pre-establishment commitments for investments in certain critical sectors, such as fossil fuel exploration, production, consumption. And finally, there's also the reverse side of this. Investment agreements have also been shown to be potentially useful to counteract, to or sort of to support mitigation policies. And recent facilitation disciplines in investment agreements should perhaps be used to focusing, for example, on regulatory coherence disciplines in order to improve domestic regulatory processes requiring transparency and public consultation and regulatory impact assessments, as well as expanding disciplines dealing with responsible business conduct aimed at ensuring greater quality of FDI, so-called sustainable FDI. So there are also not just negative policies eliminating the protection to certain industry, but also there are positive policies trying to facilitate and improve the quality of FDI. And I stop here. And in fact, I pass the word to my colleague Megan Bowman, who will deal or take the perspective of finance. Megan.
Thank you so much, Federico. Thank you to everyone for joining us. And I particularly want to thank Clara for bringing us all together with the incredibly able assistance of Leslie Ann. And to all our fellow panelists here today, such wonderful colleagues and experts, so lucky to have such a wealth of incredible expertise right here. And the King's sustainability team, especially Ellie Bignall in the comms team, and Professor Franz Burkhardt, the Assistant Principal of Climate Sustainability. I think we're all just so grateful that we have the space and the support here at King's to be able to explore these issues in a place where sustainability is a core priority to the university's strategic vision that is threaded through everything we do, through education, research, engagement, and leadership. And there's more to do there, of course, but this event is symbolic of that intent. So there's two things that I want to highlight in the very brief time available to me to my intervention. One of the lovely things about going last is that I get to go off piste a little bit, but I have to do so economically. All right, so I've got two things that I want to cover. The first is I do want to pick up where Clara and Federico left off. And I want to focus not specifically on finance, but more generally actually on corporate actors and financial institutions and the implications of this advisory opinion for those types of non-state actors in terms of domestic, national level regulation and also litigation. And I do note that one of the questions in the chat, Liesl Halle-Müller asked, can you have a bit of a chat about that? So let's, all right. The second thing that I want to have, that I want to cover or just really touch on is the role of intergenerational equity and youth advocacy in bringing this advisory opinion to be. Yeah. So that first topic of implications for corporate actors, including financial institutions, and we see in paragraph 95 of the advisory opinion, this clear statement that the court decides that the inquiry must have a broad material scope, is the words that they use. It encompasses not only states' obligations concerning their own acts and omissions, but also of non-state actors within their jurisdiction or effective control that result in the climate system and other parts of the environment being detrimentally impacted. So it's very, very clear, which I think is really exciting. And the first place I want to sort of focus is potential implications for litigation, national level corporate litigation. So as Clara explained, the ICJ has said fossil fuel exploration licenses, subsidies, production could constitute internationally wrongful acts which are attributable to states. What I want to do is take that and triangulate it with some, there's not three, two, and bilaterally intersect it with jurisprudence that's coming out of national courts vis-a-vis corporate actors. And particularly, I'm going to really focus in on the Shell and Milieu de Foncier appeal decision from last year that came out of the Dutch Court of Appeal, which upheld the lower court's finding that companies like Shell, and I quote, have their own responsibility in achieving the targets of the Paris Agreement. And that's partly because they've contributed significantly to the climate problem, but also because they've means, sometimes more means than some countries, to help combat it. And obiter, in that Court of Appeal decision findings, it was stated that new oil and gas expansion may be illegal. So big implications around that, around future claims that ought to focus, I guess, on expansion, either by fossil fuels themselves or even potentially investment in new oil and gas fields. And that's not just the sort of trade investment that Clara and Federica were talking about, but also the natural financial flows from financial actors, banks, insurers, institutional investors within country. So that jurisprudence that we're seeing coming out vis-a-vis the responsibility of companies, when sort of coupled with what we're seeing around state responsibility for regulating those actors, we're really beginning to see, I think, a really potent messaging and sort of mosaic about the number of actors that are relevant to what I would call responsible climate governance, which includes governments, but also companies, firms, financial institutions, and civil society as well. Does this give rise to potential corporate litigation? You bet your bottom dollar, I think it will. I mean, for example, already Milieu de Foncier is already appealing that Shell decision up to the Dutch Supreme Court, and it's using that language around corporate accountability as its basis. And it's just recently launched an action against a bank, against a financial institution, for facilitating what we call financed emissions of major polluters. That's the case against ING. And we certainly see, lawyers at Client Earth, Liam and Klingst, has come out recently and said, and I quote, "The judges have sent a clear message to corporate and financial giants: the age of producing and bankrolling fossil fuels with abandon is over." And we could debate whether that's an accurate statement, but the point is, people have got their gloves on. Them's fighting words. Even the head of the European Central Bank, Frank Alderson, back in 2023, mentioned in a speech that financial institutions and even individual board members who make these emissions and fossil fuel projects possible can expect increasing climate litigation to come their way. So what I think the point I'm making is that when you take what has come out of this advisory opinion together with the sorts of messaging that we're getting from national level cases against companies or involving companies, that we're really gaining, I think, a convergence of messaging. We are seeing a definite line of travel around this mosaic of responsible climate governance. The second thing I want to mention is about regulation. Yeah, as we've already identified, the court affirms governments must not only reduce their own emissions, but also regulate companies to do the same. What does that mean? Well, in a perfectly functioning world, it would mean more national legislation, regulation, administrative procedures, enforcement mechanisms, and so forth, aimed at either specific and also incentives. I mean, as Federico pointed out, that the regulation legislation is not only punitive; it can also be incredibly incentivizing and mobilizing. So more of that sort of regulation aimed at either specific sectors, particularly high-emitting ones or hard-to-abate ones, or with blanket application to all firms and financial institutions. Now, the big question, the question that interests me in the kind of work that I do, is something that Lesley-Anne touched on and telegraphed in her opening comments. And she phrased it in terms of trade-offs at the domestic level. And obviously, the ICJ has not gone into detail about that, because one would assume that that's something for domestic consideration. But the big question is this: what type of legislation or regulation, and what mix of legislation and regulation at the domestic level is going to be most effective to implement the messaging of this advisory opinion? And so far, really, particularly in G20 countries, but slowly more and more spreading around the world, the focus has been on informational regulations. So enhanced corporate reporting and disclosure obligations, for example. More and more we're seeing anti-greenwashing, for example, legislation and regulation. What are the implications of this advisory opinion for that, for regulatory tools and regulatory mixes is the question. And I think at its most expansive, we could simply say this: tweaks at the edges are no longer going to cut it. What does that mean? Well, we could have a whole nother seminar on that, and maybe we should actually, but here's some ideas I'm just going to throw around, having had 48 hours to think about it. Mandatory transition plans with accountable milestones. They exist already in only a few jurisdictions, and there's been some sort of resiling from that in other jurisdictions, but that I think is definitely the future. Mandatory transition plans with accountable milestones, amendments to existing directors' duties in company law, and that could include anything. If strongest level, perhaps a duty of care and a duty to act, and obviously some robust discussion around how that might sit and fit with current duties to the company and shareholders. Heightened capital requirements and supervisory requirements for financial institutions under the Basel III rules, and domestic prudential regulation. Stronger incentives for research and development for alternative aviation fuels and shipping fuels, for example. And I think even command and control, what we in regulatory circles call command and control regulation, that actually not just steers firms, but commands and bans. So potentially, outright bans on new fossil fuel production, or redirecting investment into greener and sustainable areas, or even forcing much more prompt change in sectors like transport and energy. So there's, and I've barely touched the iceberg. I think there's a whole discussion that needs to happen around that. But what I want to emphasize here is a further implication of all of this, and it's something that Sue touched on, and it's our role. It's our role as advisors, legal and financial, as employees, as leaders, as intellectuals, as lawyers, as people who care about the world in which we live and the health of the planet, and all sentient beings on it, that we start having these conversations with our bosses, with our clients, with our students, with our peers, something along the lines of this is the direction of travel. How can we ride it rather than resist it? Oh, and by the way, I've got some ideas. That is an incredibly exciting implication, one that's relevant to every single one of us in this meeting at this moment. Finally, so quickly, comment about future generations and the youth. Certainly the phrase future generations and intergenerational equity, I mean, this really interests me for a project. This is a field in which we're working at King's, and so exciting to see that phrase, future generations, is really integral to both questions put to the ICJ and mentioned again in various points throughout the opinion. It's also notable, I think, that several state delegations featured youth representatives and advocates, the Netherlands, St. Vincent and Grenadines, the Organisation of African, Caribbean and Pacific States. It's so wonderful when you read who was represented at the beginning of the opinion, to see that. Now, this isn't necessarily surprising. It's really exciting. Not necessarily surprising, given that this whole advisory opinion journey began back in 2019. It was the brainchild of a group of young Pacific Islander law students who were studying in Vanuatu at the time. And one can only imagine from their point of view, as Sue mentioned, the island states are so vulnerable. And they are seeing before their very eyes their homes disappear, their ancestral sites disappear, everything that they hold dear, and that gives their life meaning. So this is frontline stuff for them. It's not just a nice intellectual idea about principles of international law necessarily. It's about how do we turn back the tide. So what I'm really excited about is this presence of youth voice in this, and that imbues the questions and was present in the room at the time of this advisory opinion. Certainly the IPCC has said that actions taken before 2030 will have impacts, obviously not just now, but for thousands of years to come. That's in their findings. So we have such a rapidly closing window, and the obligation, obviously, to act sits on today's decision makers. So the other thing that comes out from this advisory opinion is the emphasis on long-termism. Where future generations are mentioned, it's often with this flavour of long-termism, particularly around risk assessments, and the fact that they state in paragraph 157 the interests of future generations and the long-term implications of today's conduct need to be taken into account by states when deciding and implementing their policies and measures. So I really think this is a really important vindication of bringing the concerns of the youth to the world stage, and that this advisory opinion has so much importance, not just for the words and the concepts contained within it, but for the journey of how it came to be. And it reminds me, actually, one last thing, and then we'll go to Q&A. I happened to come across a quote by Nick Cave, the Australian musician, yesterday, and he was speaking about grief, actually, but it somehow felt relevant to what we're talking about today and to this advisory opinion and the direction of travel that we are definitely on. and I'll take just an excerpt from it, but he says this hopefulness, and Sue mentioned hope. Hopefulness is not a neutral position. It is adversarial. It is the warrior emotion that can lay waste to cynicism. And I want us to hang on to that as we think creatively and deeply about the implications across all levels and sectors in the world of this advisory opinion.